Next speaker is Professor Marie Lofaso, and after her will be Eric Schweitzer.
Good morning, Madam Chairman and honorable members of this board. My name is Anne Marie Lofaso. I am an Associate Dean and Professor of Law at West Virginia University, where I write and teach about labor law. I also spent 10 years here at the National Labor Relations Board in the Appellate and Supreme Court branches, and I have a doctorate in comparative labor law from Oxford. The board should be commended for acting under its statutory rulemaking authority to modernize outdated and confusing rules. The current rules are in some cases redundant, in other cases there is no rule at all, which results in regional variation, which in turn leads to unpredictability. It also allows unscrupulous parties to take advantage of built-in bureaucratic delay, resulting in tactical delay. These amendments, while modest, will go a long way toward fixing the well-known problems associated with the current election rules. This is good government acting at its best. The views of affected parties are well understood. Employers want longer time periods to attempt to persuade their employees not to form a union. Unions want shorter time periods because they fear that the longer time period, the greater the chance of employer interference. But the question for this board is not whether longer or shorter time periods are perceived as favoring one party or another. The question for this board is how it can most fairly and efficiently determine whether employees want representation. These amendments give employees a final and fair resolution on the question concerning representation without unnecessary delay. I have 3 points to make. These amendments modernize outdated rules and make them more readable, make government run more efficiently by liberalizing information and by addressing the main problem of delay, while still allowing ample time for full debate, and deliver better service to the public. These amendments strengthen the secret ballot election process, a process that the Chamber fought so hard to maintain. Point 1. These amendments modernize the election rules by permitting the electronic filing and transmission of documents. These changes are consistent with the efforts of other tribunals to modernize their own rules, such as the Electronic Case Filing Initiative of the federal courts. The board's efforts to make the rules more readable are also consistent with the efforts of other tribunals, such as the Federal Courts Restyling Project, an effort to rewrite all federal rules in plain English. Point 2. These amendments also make government more efficient in 2 ways. First, they liberalize information available to all parties. The basic requirement for an efficient process is greater initial information. The amendments require parties to release information readily within their control, no later than the pre-election hearing. Information such as the names, addresses, telephone numbers, and email addresses of employees is information that is well within an employer's control. This, too, is consistent with the recent developments of mandatory initial disclosure under the federal rules. Similarly, the amendments require the parties to submit position statements no later than the pre-election hearing. To make it easier for the parties to comply with this requirement, the board has offered the assistance of a hearing officer. This amendment provides a mechanism for quickly identifying the issues. This, too, is consistent with the trend in federal pleading requirements, especially after Iqbal. The purpose of raising issues in the early stages is to resolve issues as quickly as possible so that non-meritorious issues do not go any further, which would result in lost resources. These requirements do not favor either party. Instead, they make the first steps in the process clear and more efficient. These amendments also make government run more efficiently by streamlining election procedures. The current system encourages death by 1,000 cuts. The amendments eliminate unnecessary bureaucratic delay, thereby diminishing opportunities for unscrupulous parties to take advantage of systemic delay. By eliminating pre-election voter eligibility challenges that are unlikely to affect the election and pre-election requests for review, by giving the board the discretion to deny post-election rulings, thereby allowing the regional director to make a prompt final decision, and by consolidating review of the regional director's rulings through a single post-election request, the board's efforts are, once again, consistent with the federal rules under which litigants get only one pre-answer motion. Point 3. These amendments also deliver better service to the public, not only by modernizing the system and making it run more efficiently, but also by creating uniformity, which leads to predictability. Predictability is always good for business. Uniform standards also leave less room for unscrupulous parties to game the system. Opponents of the rule inaccurately contend that the rule cuts off debate. These amendments deal only with the time period between the election petition and the election itself. Employers and unions have ample time to make their views known during this time period as well as prior to the filing of an election petition. Indeed, many employers now show as part of their first day orientation short films about why unions are unnecessary. Let me conclude with this. If some employers are truly concerned with full debate, I suggest that they give unions access to their property and debate the pros and cons of unionization. Thank you for your time.
Thank you for your thoughts. Colleagues have questions? Since you talked about uniformity, I wondered if you would want to reflect on the prior speaker's comments that this will actually result in less uniformity because there'll be regional directors making different decisions rather than just the board.
Well, but there is guidance, first of all, in terms of, this is procedural guidance. If what he means by that is lack of substantive uniformity, there is actually a review process that the board will have. There's still a post-election review. So the board would be able to maintain, which would be I think would be very important for national labor policy.
Thanks for being with us today.
Thank you.
Sharing your thoughts.